But I want to say something
read first, and then we can
about what you say about the courts.
Yes.
Courts enforced even patently unjust laws made by Parliament. Their jurisprudence was inspired by positivism, a theory of law that teaches that law is valid because Parliament says so, and it is always binding on the courts. Courts are obliged not to second guess or remake the law, but only to interpret and apply the law. In that way, apartheid judges, not like Pontius Pilate, the Roman governor of Judea, who was known for having presided over the trial and crucifixion of Jesus, washed their hands of the unfairness of the outcomes they ordered. In light of this phrase here, Judge, are you able to give us a defense today against those who are calling for a parliamentary democracy?
Yes, yes. Parliamentary democracy is actually unrevolutionary. It is retrogressive. It seeks to place untrammeled, complete power in the hands of the majority in Parliament without safeguards that would make democratic experience for the people truly progressive. Let me restate that. Parliamentary democracy was introduced in our country by colonial arrangements. It is what is observed in the United Kingdom, and they extended it to all their colonies. Through it, if you secure a majority, your will be done. If you made laws that people of African origin may not become voters, that law would stand. And that law may not be overturned at all. Why? Because Parliament says so. So in jurisprudence, in legal philosophy, that's called positivism. Once stated by Parliament, there can be no derogation. There can be no departure. There can be no except from that law. Remember in the olden days, Parliament ruled that women will always earn 2/3 of what men earned. That was law. Parliament ruled that there will be the death penalty, and there's no debate beyond that, whatever other views might have been. And that executed how many of our comrades? Hundreds of them were killed by a regime that was resisting a demand for democratic change. So be careful what you're asking for. Be careful whether you want to place in the hands of a majority in the government of whatever, unity of disunity or whatever. If a majority can make a law that says 2/3 of the fiscus must be spent in the Western Cape, that is what it will be. There'll be no room for review, judicial or otherwise. And we lived through that system. We saw its oppressive outcomes, and they were deleterious. And we chose quite consciously that the people must remain and always make the law in Parliament. But that law must have certain strictures that does not allow the majority to go gung-ho against those who are not part of that majority. Tyranny of the majority does not always translate to democracy. And this is something that we should repeat and remind ourselves and not be ahistorical about what parliamentary sovereignty means. In that system, judges would then do no more than rubber stamp what the law does. All African males will carry passes, and if they don't have the passes on their person, they are liable to be thrown in jail without a warrant. That was the law. No, Robert Sobukwe will stay on Robben Island for as long as Parliament says so. And Parliament passed the law every year, though he had finished his sentence, to keep him on Robben Island. Okay, so tyranny could come through parliamentary arrangements which have no checks and balances in them. In that setting, you'll almost never have a motion of no confidence in any leader because the majority is there. Once the majority is there, that's the end of the debate. And there are no processes to check on them. Now, let's go to the other side. Should judges create a judicial tyranny? Answer is no. And I spent a lot of time to write about that. Only Parliament makes law. Judges don't. Judges are called upon at the instance of a citizen or a body, whether or not the law violates fundamental rights and freedoms. Now, in modern societies, it's unthinkable that there would be no fundamental rights and freedoms. In a parliamentary sovereignty, you have no Bill of Rights. You know that. Because somebody has to test your right to freedom, to your right to whatever. And the courts have to test that, where the state has violated them. So when you call for parliamentary sovereignty, in effect, you're taking a Bill of Rights, a minimum rights that every citizen must be able to rely on. You throw them through the window.
Are you able, Judge?
Parliamentary sovereignty versus constitutional supremacy. Which way for South Africa? Welcome back to IZWI LABANSUNDU, the voice for Africans, the voice of the people. Today we are tackling one of the biggest political and legal debates in South Africa right now. A debate that goes to the heart of power, democracy, land, immigration, transformation, and even the future of our constitution itself. The question is simple. Should South Africa continue under constitutional supremacy, or should we move toward parliamentary sovereignty? Who should have the final say in this country? The elected president or the constitution and the courts? This debate is becoming louder every year because many South Africans are frustrated. They believe elected leaders are being blocked by judges, constitutional institutions, and legal processes. Others say without constitutional supremacy, South Africa will become dangerous, unstable, and authoritarian. Today we break it all down. What is parliamentary sovereignty? What is constitutional supremacy? Why did South Africa choose constitutional supremacy in 1996? And which system actually serves the people better? Let's get into it. Part 1. What is parliamentary sovereignty? Parliamentary sovereignty means Parliament is the highest authority in the country. If Parliament passes a law, that law is final. No court can overturn it. No judge can cancel it. No constitution stands above Parliament. The elected representatives of the people become the ultimate source of power. This system existed in South Africa before 1994 under Apartheid. Under parliamentary sovereignty, Parliament could pass almost any law it wanted, and courts had very little power to stop it. That is exactly how apartheid laws were enforced. Parliament passed laws on racial segregation, land dispossession, passed laws and political repression, and courts could not strike those laws down simply because they were unjust. Why was that? Because Parliament was supreme. Now, supporters of parliamentary sovereignty argue that this system is actually more democratic. They ask, why should unelected judges have more power than elected politicians? Why should courts block laws that Parliament passed on behalf of millions of voters? This argument has become stronger in modern South Africa, especially when courts intervene in political matters. Many people feel judges are becoming too powerful. Part 2. What is a constitutional supremacy? Now, constitutional supremacy is the opposite. Under constitutional supremacy, the Constitution is the highest law in the country. Not Parliament, not the President, not the courts. The Constitution itself is supreme. This means if Parliament passes a law that violates the Constitution, the courts can strike it down. If the President acts unlawfully, courts can stop him. If government abuses power, the Constitution becomes the shield protecting citizens. This is the system South Africa adopted in 1996 after apartheid ended. The reason was simple. The architects of the new South Africa feared what could happen if Parliament had unlimited power again. Remember, apartheid itself was legal under parliamentary sovereignty. That experience convinced many liberation leaders and constitutional negotiators that South Africa needed safeguards against abuse of power. That is why the Constitutional Court was created. That is why the Bill of Rights was introduced. That is why courts gained the power to review laws and government actions. In theory, constitutional supremacy protects democracy, minorities, and human rights. But critics argue that in practice it sometimes weakens democratic decision-making, of which is true. Part 3. Why this debate is growing in South Africa. Now, let us talk about why this debate is exploding today. There are several reasons. Number 1, land expropriation. One of the biggest issues is land reform. Some political groups believe the Constitution slows down radical land redistribution. They argue property rights protections make it difficult for Parliament to move aggressively. Others disagree and say the Constitution already allows land reform. Government simply lacks political will and administrative capacity. But this debate has caused many people to ask, should elected representatives have unlimited power to transform society? Or should constitutional protections limit them? 2. Immigration and border control. Another issue is immigration. Many South Africans believe courts and constitutional protections prevent strong action against illegal immigration. Some activists argue that national sovereignty and public pressure should guide policy more than constitutional litigation. Others warn that weakening constitutional protections could lead to xenophobia, abuse, and violations of human rights. Again, the question emerges, should majority opinion always win? Or should constitutional principles protect everyone, including unpopular groups? 3. The power of the courts. Another growing issue is judicial power. South African courts have become extremely influential in politics. Courts have ruled against presidents, against ministers, against parliament itself. Think about major rulings involving corruption, nkandla, state capture, elections, Phala, etc., etc. Some South Africans celebrate this. They say courts are defending democracy, but critics say judges are entering politics. They argue judges are now shaping national policy instead of merely interpreting the law. And that raises a dangerous question. Who governs South Africa? Politicians chosen by voters or judges appointed through legal processes? Go to the comment section, guys, and give me your own views pertaining this matter. Thank you for tuning in. My name is Debus Kosana, Kamakuma Africa.